When it comes to buying property out of a probate situation, the Succession Act 1965, Section 50, gives the executor or the administrator of a deceased estate the power and the authority to sell the property, to deal with the property. However, it is a necessary document of title if you're purchasing the property, the grant of probate, or it may be a grant of letters of administration in an intestacy situation, or it may be a grant called a de bonis non. But regardless, it's either a grant of letters of administration or a grant of probate that's required. That's an important document of title and will have to be obtained. How long, how slow is the process? Very much depends. It's really a question of how long is a piece of string, but you'd probably be wanting to allow 6 months anyway. And I've seen some situations being faster than 6 months. I've seen some longer than 6 months. And if you think about it, it'll depend as well. The speed with which it's done will depend on the will itself, how many beneficiaries, and a lot of factors. It'll also depend obviously on when the application is made by the solicitor, how quickly the relevant information can be gathered in order to make the application, PPS numbers perhaps, tax details, previous gifts. The number of beneficiaries then will be important as well, because that'll all have to be reflected in the tax document that has to be submitted. It used to be the CA24, I don't know what it's called now, S2 or something it's called. It's an online application to revenue. But the fundamental point is that you really don't know how long it's going to take. You probably could allow 6 months, certainly, for the grant of probate or grant of letters of administration to issue. Now, you may well be asked to sign a contract, and when you're purchasing from an administrator or an executor, a probate situation, and you'll be asked to sign the contract, and you'll be asked to pay a deposit perhaps, and then the closing date will be contingent upon the grant of probate or grant of letters of administration being issued. Once that's issued, then the sale will close, but not until then. So it is possible in that situation that you could be expected to sign a contract, pay a deposit, and then perhaps wait 6 months for the thing to close. Now, you may be willing to do that. It depends on the market, it depends on the property, it depends on your own personal circumstances and so on. But, some people are not going to be prepared to wait that long. So that's the story with grant of probate. No difficulty, no problem with probate sales, apart from the delay. And obviously, if you're purchasing, then you're completely dependent on the other side, the other solicitor, getting the application in and dealing with any queries expeditiously. And the probate office has to be exacting, has to be demanding, has to be very thorough in looking at applications. So it is quite often, and it's quite common for queries to arise and papers to be sent back again, applications to be rejected, amendments to be made, and so on. So it depends, as I say, on the particular case. It could be very straightforward, or it could be more complex, and then it depends on the degree of care that's gone into the application that's gone in. That will be a factor as well in how quickly the thing is issued and the will is approved. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.